Every day in the USA, people find themselves in court.
We're going to take up two files. Each file is entitled People of the State of Michigan versus Dean Jacob DeMambro. The two case numbers are 25-14037FH and 14038FH. Appearances from counsel, please.
Jay Carnes on behalf of the people.
I'm Jeff Harrison. I'm here on behalf of Mr. DeMambro.
Mr. DeMambro joins us via Zoom from someplace.
Lake County Jail.
Lake County Jail, down in the beautiful city of Baldwin. Mr. DeMambro, are you able to see and hear us, sir?
Yes, sir. I am.
Thank you. All right, folks, we are here today for a motion for joinder. That is to combine these two cases for trial. I see, and we also have a motion to adjourn the trial dates. Let's take a look here first at the motion for joinder. I have the motion. It was received in our office back on the 15th of April, and I don't recall seeing any response. Was there a written response?
I did not file a written response.
All right, that's not necessary. I just wanted to see to make sure I didn't miss one. All right, so tell me, first of all, do we have an agreement, or do I need to entertain arguments?
We do not. I was expecting to briefly place arguments on the record.
All right, let's go to arguments then. Mr. Carnes, give me just a second so I can space out these two files and look at the felony information for both. Right, so we have a file ending in 3-7. The defendant is charged with an offense allegedly occurring on July 30th. In the other file ending in 3-8, I also see that it is an alleged offense occurring on July. I'm sorry, I said July. I meant January 30th of this year. I will note that it looks like both sets of files originated from the City of Cadillac Police Department. Both files involve report numbers that are from that department, and also they're sequential. And I'll also know that they allegedly occur within the City of Cadillac here in Wexford County. One file, and in 3-7, involves an allegation of unlawful drive away of a motor vehicle. And the second file, and in 3-8, has to deal with flee and elude a police officer. All right, go ahead, sir.
Thank you, Your Honor. The alleged facts here, the victim in file ending in 3-7 called in a report that her car had been stolen by the defendant. Two city police officers responded to her location, took down all the information, put a P on the lookout in the system for the automobile. And then in the second file, it's alleged that Sergeant Izzard was out on patrol in his vehicle, saw a vehicle matching the description, pursued it with his lights on, and the vehicle accelerated quickly, and he stopped the pursuit for community safety purposes.
He ceased the pursuit, so that allegedly the defendant got away.
Yes, Your Honor.
Was any of that pursuit caught on a dash cam or body camera?
It was caught on a dash cam, Your Honor.
Does anybody identify the vehicle that the officer was chasing to be the vehicle belonging to the person who allegedly said it was stolen?
Yes, Your Honor. Thank you.
All right.
That Sergeant Izzard did look and match the license plate.
All right. And how much time had transpired from the bolo being issued and the location by the, do you know?
My impression, based on the preparations I did for the preliminary exam, which I don't believe, I think it was waived.
No, I see.
I'm sorry.
Yeah, I see two transcripts here.
My recollection from that was it was about 15 minutes after the BOL. This all took place in the same time frame.
All right. Thank you.
Thank you.
Mr. Harrison.
As portrayed by Mr. Carnes, I believe that's a factually accurate assessment of the evidence as we know it to date.
Okay. looking at Michigan Court Rule 6.120, when considering the joinder and as to whether or not it is appropriate, the court must look at a series of questions. The first here is that it is the same conduct or transaction. The second is that a connected series of acts, and number three is that a series of acts constituting a single scheme or plan. At least while this court does not find or make any finding as to guilt for the purposes of the motion, the court taking the facts as presented by the prosecution, as well as having previously, I've had this motion now for about a month, and I'm taking a look at the preliminary examination transcripts, which the court incorporates herein by reference. The court finds that there allegedly involves the same series of same conduct transactions. In fact, fleeing from the law enforcement officers would be part of stealing the vehicle and taking it away. And because we have largely, someone's going to have to identify that is my car in that video. And yes, I ran the plates. It's all going to tie down, presumably, to the same, it sounds like, without any doubt, that it involves the same, not beyond reasonable doubt, not beyond a doubt for a finding, for a finding of guilt, but at least for today's purposes, a finding that this case or these two cases involve the same series of connected acts, the same conduct and the same transaction, and all constitute a single scheme or plan, which is to get away with the vehicle. And whoever was, of course, we didn't get this told me yet, but I can read between the lines. Well, no, wait, news never stopped. Is there any evidence that shows that the defendant was identified by anybody?
Your Honor, there's circumstantial evidence with the victim's testimony that I left with her car. And then the next day, the day after these events, she was able to retrieve her car based on text phone communication with the defendant. So she's a key witness in both.
Okay, and did she know the person
Yes,
who took the vehicle?
she does. Yes.
Oh, so when she saw
yes.
when she saw a person drive away in her vehicle, she is able to identify that it was this defendant.
She knew exactly who it was. She told that to officers. Yes.
Therefore, the court finds that there is sufficient evidence and legal authority to have these two cases joined into a single trial. That addresses the joinder question. Mr. Carnes, you're going to need to draft an order to that effect. Okay, next one. We have a motion to adjourn trial dates. Looks like here this case is set for what date? Yeah, fine. Not the 17th. It's the 10th.
Yeah, June 10th.
And okay, I see. So the officer in charge of the case. All right, thank you. All right. Again, I didn't receive any written response. Your position, anything further to add to your brief?
Your Honor, I just point out that there's no judicial economy wasted here or the 180-day rule because there's a third file that has nothing to do with these two. The people are prepared to go forward with that file on the trial date. So I think I would ask the courts to grant the motion for many purposes. Thank you.
Mr. Harrison.
We don't take a position as to the reasonableness of the people's request. And I concur that there is a third file that could be tried independent of these two.
Yeah, I'm looking here at the current docket for that June 10th, and there's one particular file, which I assume is the one the parties are talking about, has definitely repetitively taken the position that it will be a trial.
Mhm.
And the only reason it was last delayed, I think, was because of new counsel being appointed to it. So therefore, the court grants the motion for good cause. The the plaintiff does have a right to present witnesses, and therefore the court finds good cause. All right. If you could please draft an order that grants both motions for the reasons stated on the record today. All right, anything else on behalf of the people, Mr. Carnes?
Your Honor, one order for both motions. Okay with the court?
Yeah, one, and you should list both case numbers at the top. You should submit one copy for each file, so each file will have an original signature.
Yes.
Copy that, thank you. All right,
I have nothing further, Your Honor. Thank you.
all right. Mr. DeAmbro. We had a hearing today addressing two motions by the people. I have granted those motions. These cases, we are currently set, or we're set for a trial to begin on June 10th. Those have been, that trial date will be adjourned. I want to know here, Mr. Counsel, there's a third file,
There is.
Yes.
but it has nothing to do.
Nothing to do with this.
Well, right now, one of those is still set on the possible
That-
trial date. So
that
that's that's when you guys
my
talk.
point of not, yeah, and they
Detail.
wouldn't be appropriate right now.
Very much.
Yeah, we did the prelim together, though. That's right.
All right. Thank you.
Thank you, Your Honor.
Mr. D'Ambro, any questions about what we have done today, sir?
Yeah, what trial is being canceled or adjourned?
Yes, sir. Yes, sir. First of all, Mr. Carnes, why don't you tell me what file ending in 3-9 involves?
That involves an alleged flee and elude situation with the Michigan DNR.
On a total different
Completely
day.
different date. It was a couple months prior to this. This
Okay.
involves the matters that have been adjourned involve the city police within Cadillac.
Mr. D'Ambro, there are three files. I'm just going to call them 37 and 38. Those have now been joined for trial. That trial will be adjourned due to the unavailability of the officer in charge of the case. The other file ended in 3-9, which has to deal with a completely unrelated allegation allegedly involving a flee and elude of a DNR officer. That case is still currently set for trial on June 10th. It is, however, one of multiple cases set for that day. We will be on the record on that file on May 23rd. On that day, that will be a day we'll ask if there's a plea or if it's going to proceed to trial. All right. Any other questions, sir?
Yes, I heard the prosecutor made a statement that Mrs. Saltman identified me, and that is not true. She said under oath on the stand that she did not see who left the parking lot in her vehicle. The prosecutor said that she identified me.
All right, well, there's still the issue of identification as to with whom she obtained or received the car. Regardless, the court finds still that there are grounds to have the two cases joined for a single trial. Thank you. We are adjourned.
Thank you.